Hello everybody, welcome again to 12 Minutes to Clat. I am Keshav Malpani and we are going to discuss about the Maratha Reservation today and the subsequent recent decision of the Supreme Court of India delivered on May 5th, 2021 itself. So before jumping on directly to the Maratha Reservation, let's first understand the reservation in India. Okay, what is the law on reservations in India? So we'll have to trace a little bit of background history for that. Okay, so Article 340 of the Indian Constitution provides the power to the President of India to basically, form any commission for the upliftment or the advancement of the socially and educationally backward classes, which is called SEBC. Okay, for these SEBCs, for their upliftment, any commission can be formed, and commission can give certain recommendations as to how to improve their situation in the society. So in 1979, such a commission called Mandal Commission was constituted and was headed by the then Prime Minister Mr. Morarji Desai. ठीक है, तो 1979 में ये हुआ. Now 1 year later in 1980, in December 1980, the commission, the Mandal Commission came up with its report. In this report, it stated that other than the SC/ST category, there is another category which should be added, which is the OBC category, the other backward caste category, because under the SEBC, which is the SEBC class, there is obviously 52%, okay, there are 52% of the population which fell under the OBC category. So they also required some kind of representation or reservation so that their situation can be bettered. Basically, they can also become more advanced. Now this was done. Okay, so basically they also recommended that 27% of the reservation should be for the OBC community. So earlier there was 23% reservation for SC and ST community, so total it became to 50%. Okay, now this happened in 1980, the recommendations of the Mandal Commission. Now what happened is in 1980, the Janata government, the Morarji Desai's government that was there at the center was dissolved and Congress came again. Okay, so from 1980 to 1989, it was the Congress government at the center, and Congress government did not actually implement any of the recommendations which were given by the Mandal Commission. Okay, so 1989 तक इसमें कुछ भी नहीं हो पाया. Now 1989 what happened was Janata Party again came to power and it issued an office memorandum which stated that the recommendations under the Mandal Commission is to be implemented from now on. Now, after this was done, there was a lot of violent protests all over the country for a period of 3 months at least, and there was a lot of loss of property and of life as well as in certain circumstances. Now, in 1990, what happened was the Janata Party government again was dissolved. Okay, so in 1990, the government under PV Narasimha Rao as our Prime Minister, they actually amended the office memorandum slightly in the sense, they said that merely being from the SEBC category, which is the socially and educationally backward category, does not solve the problem. They also introduced the economic section into it. Okay, so basically they said that if the people from SEBC are economically weaker also, then they are to be uplifted, otherwise not. In fact, they give additional 10% reservation to the people who are from higher caste but were economically backward. Okay, so 10% reservation was given to that also. By then in 1990, this matter had gone to the Supreme Court of India, and Supreme Court of India via 9-judge bench delivered the decision in the case called Indira Sawhney versus Union of India in 1993. So Indira Sawhney is a landmark judgment on the issue of reservation in India. So let's understand as to what was held in this judgment very briefly. Okay, so the Supreme Court held that the backward classes or the SEBC, the economic criteria cannot be considered unless there is a robust mechanism, or basically there is a proper mechanism to understand as to how it is to be implemented. So they said that the caste system is to be taken into consideration and economic criteria cannot be taken into consideration. Another very important part of the judgment was the maximum ceiling was imposed on the amount of reservation that can be granted. Okay, so the maximum ceiling was 50%. So obviously merit is also to be considered. So ऐसा नहीं हो सकता कि सब कुछ reservation के अंदर ही चला जाए. So the Supreme Court held in Indira Sawhney that maximum amount of reservation that can be given by a state is 50%. Okay, and that was the limit that was set, and that is a limit that is still considered in India. Also, this case introduced the concept of creamy layer. Okay, creamy layer, all of us know the layer जिसके नीचे जो generally लोग fall करते हैं, they get the benefit of the reservation, and there are other people who do not get the benefit. Now let's understand as to what was the Maratha Reservation, and what was its salient features, and why was it basically annulled by the Supreme Court very recently. So in 2014, okay, this started in 2014. There was this ordinance passed by the Maharashtra government providing 16% reservation in educational institutions and in jobs to the Maratha community in Maharashtra. Now, after this ordinance was passed, a stay was imposed by the Bombay High Court. ठीक है, Bombay High Court ने उस डिसीजन को रोक दिया था, बेसिकली इस ऑर्डिनेंस को रोक दिया था एक बार. उसके बाद में इन द सेम ईयर इन 2014 द महाराष्ट्र गवर्नमेंट केम अप विद द सेम एक्ट. ओके, उस ऑर्डिनेंस को उन्होंने एक्ट बना दिया. The Bombay High Court intervened again and stopped them from doing this and again put a stay on the act. Now in 2017, a committee was formed of 11 members under the leadership of retired Justice N.K. Gaikwad. And what this committee or commission did was it recommended certain things for the upliftment of the Maratha community. Okay, so Maratha community basically they said that in jobs in the state, 13% reservation can be given to the Maratha community and 12% reservation can be given in educational institutions also to Maratha community because they fall under the SEBC category. So in 2018, the Maharashtra government passed an act. It was called the Maharashtra State Socially and Educationally Backward Classes Act 2018. Now, this act gave 16% reservation to the Maratha community in the state, in the jobs as well as in the educational institutions. Now, this was the amount of reservation which was not recommended by the N.K. Gaikwad committee, right? N.K. Gaikwad committee recommended 12 and 13%. This was 16%. Matter again went to the Bombay High Court. The Bombay High Court upheld the reservation but said that only 12 and 13% reservation should be given and not 16% because N.K. Gaikwad committee has recommended 12 and 13%. This matter again went to the Supreme Court. So Supreme Court initially put a stay on the entire act, holding it as unconstitutional for that time, and actually referred it to a larger bench. Okay, so a 5-judge bench was created in this particular matter, and that 5-judge bench actually held that this particular reservation is unconstitutional altogether and should be scrapped, and the decision came recently on 5th May 2021. And why did they say was there were basically two reasons for the same. First one was that the reservation breached the 50% limit. Okay, so this reservation once implemented actually took the amount of reservation to more than 60% in Maharashtra, which is not allowed because as per the Indira Sawhney judgment of the Supreme Court, which is a 9-judge bench judgment, 50% was the ceiling that was prescribed. Now there are certain circumstances under which extra reservation is also provided, basically more than 50%, but those are extraordinary circumstances. So the Supreme Court held that the Act of 2018 does not provide for any extraordinary circumstances because of which reservation should be provided to the Maratha community. Another observation of the Supreme Court of India was the reliance on 102nd Constitutional Amendment, which was promulgated in 2018. In 2018, there were basically two articles that were added to the Indian Constitution. So the first article was Article 338B. Under this, a National Commission for Backward Classes was formed. And the other article was Article 342B. 342B में क्या दे रखा था that there has to be a central list of all the SEBC, which is the socially and educationally backward communities. उसकी एक central list होगी and only the president will have the power to amend, basically to add or to minus certain communities from that. The state government, what the state government can do is they can only recommend from their particular state that this particular community is to be added or to be subtracted, but the final decision is going to be of the parliament only. Okay, so this was upheld. So the Supreme Court also held that it is not within the powers of the Maharashtrian government to basically say that Maratha community form under the socially and educationally backward community. It is the duty of the central government. But since that the notification has not come with respect to the amendment yet, basically it is not implemented yet, अब वो central list आई नहीं है. So the Supreme Court has asked the NCBC, which is National Commission for Backward Classes, to make sure that this is done as quickly as possible. So that's it about this session from my side. If you have any doubts with respect to the Maratha community reservation and the decision of the Supreme Court, please mention in the comment box. I'll be more than happy to answer all your concerns. If you like our sessions, subscribe to our channel and press the bell icon so don't miss any updates from us. Keep liking us and keep following us like this. Thank you so much.